Okay, guys, we want to try to move along with the program. As great as that panel was, we went just a little bit long, but I don't want to short this very important next topic. This topic is truly going to lead into other things, including our Kent Sterling Memorial Medication Panel on Friday. So there's a lot of crossover here that I want everybody to grasp and understand and get a understanding of where we are now. So where we stand in the trainer all-insurer rule, we have Andre Regard here today. Andre's been in the equine business and a legislative attorney in Lexington, Kentucky for over 20 years. He's been involved in the industry as an owner, a breeder, an attorney, a farm manager, which I've got a question mark by that one, and a syndicate manager for, as I said, well over 20 years. Everyone knows Peter Eckebert, our legal counsel at the National HBPA. He's been our counsel for the past 14 years.
17.
Well, you gave me the bio.
No, I didn't. 3 years ago.
17 years, I'm sorry.
That's all right.
Time flies when we're having fun.
Yeah.
But we're here today to talk about something very important, and I think a little bit of clarification. Marty and I have talked about this most recently. The trainer all-insurer rule and the pieces and parts of it. What everybody understands as a trainer all-insurer rule is a little bit all-encompassing, and some don't understand the rebuttable or irrebuttable presumption within that trainer all-insurer rule. As Marty said the other day, we have no problem as horsemen being responsible and being the all-insurer of our horses. But in that same vein, we have to be able to defend ourselves. And so there's a landmark case that has come up in Kentucky that I'm sure they'll touch on a little bit, but ultimately to give you an overview of where we stand now and where we could be in just a few weeks, if a few months. Andre and Peter, thank you.
Thank you very much. I know a lot of folks here know a lot about these rules, and hopefully you'll get some additional information today. We'll do a little bit of the history, we'll do a little bit of where we are now, and a little bit of an update looking into the future. But to start off with, as Eric just said, and we're going to touch on it a little bit more, Judge Wingate, which in Kentucky is a circuit court judge, so it's not really precedence until it goes to the appeal court. But basically, in one sentence in Kentucky, he said that the Kentucky's regulation of methylcarbamol was arbitrary and capricious. It was excuse me. He said it was arbitrary and capricious. It failed to establish a violation which occurs by administering medication that affects a horse's central nervous system, and the KHRC's creation of an absolute insurer rule for trainers is unconstitutional. That was a lot to say in one sentence, because what he brought up by saying that was, first of all, the obvious: it's an unconstitutional rule in Kentucky. Unconstitutional because of due process. And what he focused on partially was being able to establish that the medication truly affects the horse's nervous system. So there were two issues that came up. One was the actual pharmacological issue of whether or not it had an effect, so that created a defense for the trainer, and also whether or not there was due process for the trainer to even present a defense. So we're going to talk a little bit about that today. That put on its head the history of the rule, which when drug testing first came out in 1934 at Hialeah, we had a number of cases that came up in the early 40s that pretty much established the absolute insurer rule to be constitutional. The last time it was ever said to be unconstitutional until Judge Wingate happened in 1969 in Illinois. So for over 40 years, this has been considered somewhat of a settled area of law. And it's been in the last couple of years that the judges have looked a little bit more at what's really happening here, and that's where the nexus with the no tolerance rules with the, or zero tolerance drug rules are coming into play, because With your zero tolerance rules, the absolute insurer takes on another level or another challenge if you don't have a rebuttable position, because there's no tolerance allowed at all, and we'll talk a little bit about that as well. So the two issues that came up when they first introduced the absolute insurer rule: one, it was necessary for fair play in racing. That's why people wanted to do it. And what was the defense against it? There was no due process. So due process is the idea that you have a rebuttable presumption, you can present evidence, you can try to explain what may have happened environmentally, you can try to explain whether or not the medication in fact even had an effect on the horse. So that's what was pretty much litigated over the first 10 or 15 years. So this is the California rule. For example, the trainer is the absolute insurer and responsible for the condition of the horse entered in a race, regardless of the acts of third parties, except as otherwise provided in this article. If the chemical or other analysis of urine or blood test samples or other tests prove positive showing the presence of any prohibited drug substance, the trainer of the horse may be fined. So this is an irrebuttable presumption, as opposed to rebuttable. If there's any substance, then you're going to be fined. And then as we move into a zero tolerance scheme for drug testing, then basically you're defenseless as a trainer. So what is this idea of legal oppression without due process? This was one of the early, what we call a dissent, a judge who did not agree with a court finding it was constitutional, but it seems to be where we're going now. The absolute insurer rule violates every precept of justice as established by the Constitution and the laws of the United States and California. It is unconstitutional and out of harmony with the American system of justice and may appropriately be labeled as un-American. So this was a dissent in 1948. So that's over almost 70, well, it would be 70 years ago. So that's where we were 70 years ago, and now with Judge Wingate, that dissent seems to be certainly what Judge Wingate feels about it, and hopefully the majority in Kentucky. In Judge Wingate's opinion, it was not really out of left field. He did have prior case law that's recently been developed in Kentucky that he heavily relied upon to have what we believe to be a very sound holding in his case. So what's the structure of the rule? Basically, and this is one of the problems that Judge Wingate picked up on, there's inherently contradictory language in most of the absolute insurer rules. So usually when you're dealing with absolute irrebuttable presumptions in law, you're dealing with things that suggest liability without fault. But usually the rules use words like responsibility or protect and guard the horse, and those are really negligence words. And whenever you have negligence cases, you always have the ability to show what actions you took or didn't take in order to overcome the presumption of guilt or the presumption of liability. So a lot of the rules themselves are not really internally have conflicts. And in the handout you have, we've tried to, for the most of the major racing jurisdictions, at least give you a resource of where you can find the rule or find a case that may be important. So if you're in a jurisdiction and you find yourself having to go in front of the commission, and you have a lawyer who maybe hasn't practiced this in this area, hopefully you'll find that as a nice little tool to be able to give to them. Of course, the punishment usually is you deprive the trainer of their license, and a license is clearly a property right. Therefore, you bring up what we call due process. New York, it's slightly different. It's their trainer responsibility rule has a rebuttable presumption because they can show by substantial evidence that they were not responsible for administering the drug. And as I said earlier, Maryland was the first state that addressed the constitutionality of the absolute insurer rule. And nothing, until Judge Wingate in some recent cases, it had been since 1969 that this issue had been addressed. So we're going to go into a little bit of an update here. All of the cases are very, very fact specific. It's all going to come down to the facts of the case. The constitutionality of the standard is generally considered a moot point, but if you read Judge Wingate's opinion, he is looking at the constitutionality of the actual standard that the commission uses. Sanctions have generally been overturned because you have a lack of due process of the licensee, you don't have sufficient facts in the record, you didn't adhere to the substantial evidence test, or you failed to promulgate regulations in a proper way. So in Kentucky in 2015, the Franklin Circuit Court, which is the same, in Kentucky, whenever you have a regulatory matter, everybody has to go to Franklin Circuit Court after a administrative hearing. So Franklin Circuit Court is where Frankfurt is, and we have 2 circuit judges there. So in 2015, Franklin Circuit Court in Kentucky criticized the absolute insurer rule failure of stewards to provide a meaningful consideration to mitigating circumstances like environmental contamination. So on that one, it was an environmental contamination case, and that was Weir versus the Kentucky Horse Racing Commission. In 2017, Ohio started softening the rule on reconsideration, finding that the trainer accused of leaving the testing barn prematurely not guilty. So they had an absolute rule that you had to be in the training barn, and they kind of started softening that. And then in Pennsylvania in 2017, Peter Miller was found by the Pennsylvania Horse Racing Commission to have violated the trainer responsibility statute, but due to mitigating circumstances, he was only fined and not suspended. So once again, the courts are starting to look at these mitigating environmental circumstances. I apologize, I'm not keeping up with pressing my thing here. And now we get to where we are now. Judge Wingate declared Kentucky's version of the absolute insurer rule unconstitutional. In a decision that sent shockwaves throughout the American equine legal and regulatory communities, Kentucky's rule was shot down, and it's almost as an afterthought in a fairly routine appeal of a drug overage involving a winning horse owned by George Strawbridge and trained by Graham Motion. Judge Wingate stated, trainers must be able to present evidence to rebut their liability for a violation. And the challenged rule impermissibility deprives the licensee of due process. So basically, I don't know how many details everybody knows on this particular case, but the horse had, I believe it was 7 nanograms.
2.9.
2.9, excuse me. And the threshold was 1. And there was some other issues where there was a recommendation that had been made that the threshold should only be 20. And all of this scientific evidence was presented on that, and that's what Judge Wingate was looking at partially when he decided the case. There was also a lot of other issues that had happened in some other states, and he was able to look at what happened in Pennsylvania and how the rules were established, and that's where he decided it was arbitrary and capricious. So what's happening right now? States that are presently upholding the rule are Maryland and New Jersey. States that are beginning to question the absolute insurer rule include Kentucky, Ohio, and Pennsylvania. And then we also have some international cases that have happened recently, and I believe Dr. Tobin may have been involved in one of them. But we have a case in Australia where basically they allowed a look at the mitigating circumstances. The trainer said they did not have knowledge of the Drug Administration. And then in Britain, basically they were able to look at whether or not the trainer had taken all the reasonable precautions that were necessary in order to ensure that prohibited drugs were not found within the horse. Once again, going back to the Motion case, Graham Motion was giving the horse the medication. There was no question about it, and it really became an issue of the withdrawal period. So it was an allowable medication, but a medication that tested positive at the time it tested. So now we're in the zero tolerance world. So basically, it prohibits a horse in a race from carrying with it any drug substance foreign to the natural horse. There was a lot of public perception on drugs and horses and medication after 8 Bells and Barbaro. However, in the Motion case, Judge Wingate said the court that there must be a scientific rationale for the imposition of drug regulations. So the idea that you're going to prohibit a horse in any race from carrying with it any drug substance foreign to the natural horse does not match with there being some sort of scientific rationale for the imposition of a drug regulation. So older rules use language such as used for the purpose of stimulating the horse or affecting his speed in a race. And now the goal of the zero tolerance rules are to prevent horses from being raced when they have any drug-like substance in them and preventing post-race litigation, whether that substance has any effect on the horse's race performance. So some of the arguments against the zero tolerance rule include that the rule does not have a rational basis and is therefore wholly, clearly, and palpable, arbitrary, and capricious, and cannot be enforced. Arguments for the zero tolerance rule include the drugging of a racehorse in such a way as to affect the results of a race is an evil which must be stopped whenever present and by any reasonable and adaptive methods. Peter's going to talk a little bit about best practices for defending a drug positive.
Okay, thank you, Andre. When you are unfortunate enough to have a positive test and you're contacted by the stewards, it becomes a very time-sensitive situation for you. I would suggest, obviously, to contact an attorney immediately and get an attorney on board as quick as you can. But the other thing you can do is contact the HBPA office, because most of our executive directors have experience and have gone through similar situations in the past. So it's good to get somebody in there that's had to deal with this before that can serve you well. You're obviously going to want to have a split sample taken. In that situation, you want to make sure that it's quantified. You ask that it be quantified so that they just don't come back and say it was, there was this level. You want to know what the level was. You don't want just to know that there was a positive test. You want to know what the concentration was. So you also want to be there when they package the blood or the urine to be sent off for the split sample. And if you can't be there, then again, I'd suggest maybe to contact the HBPA office in your jurisdiction and ask that a representative be there. And you want to make sure that the chain of custody is clearly proper, so that that's a defense that can be used if there's some mess up with chain of custody. I know in one situation we're talking about the vet that was taking the samples was storing them in a refrigerator in the motel because the refrigerator was, I guess, at the track wasn't working or whatever. So that was an issue that the trainer could use. We've got the issue of contamination now, and with the testing being so minute and so sophisticated, the issues, I think the judges are becoming more educated in that area and more concerned with what these positives may mean. And what I'm saying, mean to say by that is that there is no possibility that some of these positives could have an effect on the performance of a horse. When you're talking about 1 nanogram for a 1,000-pound animal, that's not going to, most of the time, would not have an effect. And the other thing you're talking about is therapeutic medications. So you're talking about maybe that the withdrawal time, the horse didn't metabolize the therapeutic medication the same as what the standard is. And so that's an issue that needs to be addressed and looked at, and the issue of contamination definitely is something that is part of the defense in any kind of a litigation that's involved in this area. You want to make sure that your record is established so that the hearing before the stewards is important, because that's where you start to get the record, and you're given the opportunity maybe to cross-examine some people and that sort of thing. So it's good to have your attorney in there. If not, get the executive director, someone who has from the HBPA who has the experience to help you out in that regard. The other things that you want to think about, because of the sophistication of the testing, is you want to look at how are the other possibilities that could cause a positive. And some of those may be that we've seen like maybe the gate personnel where, if you have a positive for cocaine or for meth, you may have a situation where you've got gate people that are using it, or people that have been in contact with your horse that have contaminated it. So you want to think sort of outside the box, or think where this kind of an issue could arise. So it's important to get with someone that has that kind of experience and has dealt with this matters before. And you may want to collect the feed at the test barn. You may want, maybe the straw, the bedding you want to look at as well, because those things can have a contamination effect and maybe part of the reason or the reason for the positive test. Deadlines here are critical, because if you get back your unfavorable decision from the stewards, then you've got 10 days in most jurisdictions, maybe shorter in your jurisdiction. This is state sensitive, and each state has different rules. So you've got to get your notice of appeal in quickly, and you can't delay. If you miss that deadline, then you miss the opportunity to appeal. And then at the administrative law judge level, where you're going to be in front of a ALJ who's going to take testimony, you have an opportunity to take some discovery, and so you definitely want to consider who needs to be examined, what kind of documents you may want to get to help help clear you. The other point would be that you may be able to get some documents through the Freedom of Information Act or the Open Records Act, as it's called in Kentucky. So that's another thing to consider as far as getting information. Your administrative law judge record, the transcript there, needs to be complete, because that's what's the basis of when you go to appeal to the next higher level, to the court, where you have what I would consider a much more objective situation and a much better chance of prevailing. You have to have that record to the lower court at the administrative law judge level complete. And part of that may be that, like in the motion case, part of the situation was the administrative law judge wouldn't let certain evidence in, and they were able to get it in. What your attorney will want to do is to put that in by a vow. And what that means is the administrative law judge is saying, I'm not going to consider that, that's not admissible, the attorney's just going to say, well, I just want to have this put in by a vow just for the appellate court to look at. And, it may not be important to you, but maybe the appellate court will consider this as something that needs to be considered. And that's what I think happened in the motion case. You have to have your record established, and it must be inclusive. So get an attorney early on and try to get the game plan set up. Obviously, whatever the drug in the positive is going to dictate what types of steps you may want to take and how far you need to go as far as who needs to be examined, how could this contamination or how could this positive have occurred as a contamination or that sort of thing, so that'll sort of dictate how you're going to address things. And the other thing I'd say is that I think that now with Judge Wingate's opinion, and then Judge Shepard in the Weir case also was critical of the Kentucky Horse Racing Commission. I think that you may see, and if hopefully the motion case, if that's successful on appeal, and it's currently appealed, and the briefs won't be finalized or won't be in until sometime in June. The commission's brief, I think, is due in March the 25th, and the horseman's briefs due sometime in April, and then May will be the final reply. So we're looking at but before the court ever starts to consider it, those have to be in and complete. And so it'll be sometime later, probably this summer, before we have any kind of opportunity or a chance for a decision in that case. But if that case comes down favorable to the horseman, then I think that, there'll be a lot of other jurisdictions that may look at this, and hopefully that is the case. Because having an irrebuttable presumption in this kind of a situation is just not, it's not fair. I mean, when you talk about a nanogram testing, you ought to be able to, I'm not saying you knock out the presumptions entirely. You have a rebuttable presumption, and that still puts the burden on you as a trainer to establish that what you did was proper, and you have to do that by a preponderance of the evidence. So that's not an easy standard, but it's something that, we all, I think, accept and recognize that we are responsible as trainers for the condition of the horse. But to say that you can't bring in evidence to show that you didn't do anything wrong, and that this was some outside force that there was no control over, seems just to be un-American, as they say, and unfair. So,
I would just stress what Peter said. So as trainers come to the various HBPAs and ask for a little bit of advice, obviously the HBPAs aren't attorneys, but if a trainer is going to go in there without an attorney, he or she needs to put as much information in the record as they possibly can. And when they go to the administrative court, even if the administrative judge says, I don't want to hear that, you still need to say, well, I want it in the record because the next court needs to look at this. And also be prepared. You're more likely than not always going to lose at the administrative level. It's kind of a stacked deck. So your administrative judge is going to rule against you more likely than not. So you better make your record so you can go to the Court of Appeals, a different standard and a different objective sense of what's going on. I'm going to skip to the last slide here for the sake of time, and then we can do some questions. But so where are we right now? So at least in Kentucky, we've had the Graham motion case that's come down, and then we've now had a situation with Rusty Arnold and Joe Sharp where they tested positive for a prohibited medication or a level, and then the KHRC withdrew based on testing issues in the lab. But most importantly, it's what Mark Guilfoyle said. He said the rule is written on paper in a way that they can't rebut, but that's not truly how it goes. At the Racing Commission, we tested whatever Joe Sharp and Rusty Arnold wanted tested. In reality, there is a rebuttal. So here is the executive director saying there is a rebuttal, and that's what happens on the commission level. So maybe the courts are catching up with what's really happening. I don't, fully know that. The courts certainly are looking at the rebuttable presumptions, though. And then Mark continued to go on to say, so we're working on changing the rule back in writing. We're going to clean it up so it reads that way on paper. That's a pretty strong statement that's coming out. Whether or not that was driven by Judge Wingate's decision, which was well-reasoned, we'll see as the appeal process goes through, but certainly we're moving towards the rebuttable presumption, and as testing continues to get better, you need that rebuttable presumption so you can look at other factors.
We're hoping that in Kentucky, again, this is a national convention, but Kentucky often is a place when it comes to horse racing regulations that the rest of the nation looks to. We're hoping that the commission will see fit to change the regulation on the absolute insurer rule back to the way it was before 2009, which did allow for a rebuttable situation. And they made it irrebuttable at that time, and it's been that way since. But with like I say, with this new sophistication in testing, hopefully, and I think the commission is seeing the error of having it an irrebuttable. I hope that's the case, and we're going to sure pursue that.
Is there anybody in the audience that has a comment or a question or an experience to share? Yes, sir. Marty.
Do you think your due process argument is undercut if the commission hears from the trainer not in rebuttal of liability, but in mitigation of penalty? For example, methocarbamol positive may call for a 15-day suspension, but instead, Graham motion tells his story, etc., and instead of suspending him for 15 days, he's fined $500.
Frank, I don't think that cuts it. Now, the reason I say that is it may cut it with respect to that individual situation, an individual violation. But the problem is you have the multiple violation rule, so that the next time something comes up small like that, the penalty that he's facing, it may be a lifetime suspension. So that the fact is that even though they may have reduced down the particular penalty in that situation, the effects of that are dire. So Marty?
I wonder, just get your all's opinion, why would you think as Andre mentioned, that right now, with Judge Wing's decision, it's not a precedent setting, but now you go before the appeals court, it's a well-reasoned opinion that you have. Why would you think that and they also, as you said, Mark Guilfoyle was saying they're going to change it, and I know he's told me that. He actually asked me to write a letter asking that. So what would be the advantage of going to the appeals court and perhaps losing, and then the rule, the absolute insurer rule, is probably disrupted all over the country?
You mean the commission going to the, because it's obviously the commission that's going to the court.
Yeah, I just don't understand their logic behind, if they're going to change it anyway, why they would feel it's important to perhaps get an appeals court that, I mean, it could go either way, obviously, but I just can't understand why they would want to go to that next level and lose when they're going to change it anyway. I don't know.
I can't answer that. I really, that doesn't, as you explained, that doesn't make a whole lot of sense. You're right. I mean, there's probably some valid reasoning behind that. I just don't see it right hand. I don't know. I don't know, Marty.
You have one question with Doug.
Doug?
Herb, finish.
Part of the thing in the, you alluded to that, part of the rationale of the case was, particularly on the arbitrary and capricious aspect, was the lack of scientific evidence for the 1 nanogram measurement. And part of the avowal evidence that the attorneys put in on that case was to show that that was outside of the realm of what even the RMPC had put out as what a threshold level should be. And I do believe, and I don't know if that's an answer as to why the Racing Commission may be continuing on with the appeal, if you're asking, Marty, but part of the problem is that it was a challenge not just to the absolute insurer rule, but also to the arbitrary nature of the Racing Commission and having set a nanogram as the threshold without any scientific evidence whatsoever to support that, nor even industry precedent. And I think that's probably where the two concepts meet: absolute insurer versus lack of evidentiary support for what the Racing Commission is trying to defend. And ultimately, the judge is in front of the record where he's got this avowal evidence and says there's no basis for this, and yet the enforcement can't even put this evidence into the record. The hearing officer below refuses to even entertain this, but there's no scientific evidence to even support it. That's arbitrary, that's unconstitutional. So with the combination of the two is what made it unconstitutional.
Yeah, I think you're right, Doug, that is, both sides of that create an unconstitutional situation. And the regulations are supposed to be based on medical evidence and science, plus the fact it's supposed to affect the performance of the horse. And if you can't establish that, then it does seem arbitrary and capricious for sure, the regulation itself, even before you get to the absolute insurer rule.
Well, thank you both. Andre, appreciate it. Andre and I have been friends a long time, used to be neighbors, so appreciate him traveling home to be here with us. Peter, as always, thank you.